Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you. Good afternoon, Mr. Altman. Can we turn to my fourth topic, please, which is the legal advice you gave in relation to the Post Office's investigation and prosecution roles? And can we start by looking at your advice on this issue, which is Poll 406802. This is dated the 19th of December 2013 on its last page. I just want to ask you about a couple of parts of it. Can we start by looking at page 4, please? Again, you provide an executive summary, and under paragraph 5.1, you say, I've seen no evidence to suggest that the Post Office exercises its investigations and prosecution function in anything other than a well-organised, structured and efficient manner through an expert and dedicated team of in-house investigators and lawyers supported by Cartwright King and their in-house counsel, as well as external counsel and agents where required. How did you come to the view that the Post Office was exercising its investigation function in a well-organised, structured and efficient manner?
I think based on what Post Office had sent to me, I had met Cartwright King, I had met Roderick Williams, I'd met Jarnail Singh once, maybe twice. And I had read by that stage certainly 2 of the prosecution files. I had more insight into Post Office through the general review. And I think the overarching view I came at was is reflected in that paragraph.
Focusing on the functions performed by investigators and your conclusion there about them, had you examined any documents or material relating to the training of investigators?
I've got an idea I might have asked for something, but I can't remember.
Had you examined the knowledge and experience of Post Office investigators?
I think I knew that some of them were former police officers.
Was that the extent of it?
I can't remember.
Had you examined the investigators' knowledge of and practical application of the law of disclosure?
The investigators?
Yes.
No.
Had you examined the extent to which investigators actively investigated all reasonable lines of inquiry, including those which pointed away from the guilt of the suspect?
No.
Had you investigated what supervision, checks and balances, if any, existed to superintend the work of the investigators?
Well, I understood that Cartwright King were involved as the external agents, and I understood that they were the instructing solicitors, and I had met Simon Clark and I'd met Harry Bowyer, and I remember being impressed by them.
That's being impressed by lawyers. I'm asking at the moment about superintendence or supervision of the work of the investigators.
No, but I rather thought that Cartwright King had that superintendence.
Had you examined how in practice decisions as to whether to prosecute or not were made in practice?
No.
Had you discovered who the decision maker was in relation to any decision to prosecute?
Well, if my memory serves me, during the course of this review, I had referred to several Post Office policies, and I think one of those policies put the hands of the ultimate decision-making in the hands of somebody who was non-legal.
Had you examined...
So, forgive me, so
Yes.
I made a point about that.
Had you examined what the training or experience of that person was?
Of that person, no, but the point I made, I think, was it ought to be in the hands of a legal individual.
Did you examine how much consideration that person gave to an analysis of the evidential strength of a case?
No.
did you examine what tests that decision maker applied when deciding whether a case was to be prosecuted?
No.
Given all of those things, how were you able to say that the Post Office exercises its investigatory function in a well-organised, structured and an efficient manner?
I think I was talking more about the hierarchical structure and what had been presented to me in the way that the Post Office, through those various policies, was structured. I don't think I was deep diving, nor do I think I was expected to deep dive all of the factors that you've just mentioned. If I had, this would have been a completely different exercise.
Do you think there was a danger in the conclusion that you wrote there being misunderstood and therefore misapplied and being used as a weapon by the Post Office in fending off criticisms of it?
On the basis of what I've just said, yes, I can see that. At the time, I suspect I didn't appreciate that it would be.
If we go forwards, please, to page 39. And paragraphs 105, 6 and 7, you say that it may be thought that the Post Office prosecution role is anachronistic and highly problematic. 106, the recent events have to be seen in the proper context. The serial non-disclosure of relevant material occurred in circumstances in which the Post Office asserts that it and its advisors were wholly unaware that there might be disclosable material or information, and so whatever the reason, were not placed in a position whereby they knew of its existence and could deal with it appropriately.
Yeah.
You tell us in your witness statement that later events proved your information and understanding that you set out there to be wholly incorrect.
I think I said catastrophically incorrect.
We'll just check that.
Which paragraph do you have?
41.1 on page 21.
Certainly somewhere I recognised it was catastrophic, or that the information I had afterwards but not then. Yeah. No, it's not in that paragraph, but certainly somewhere else I say that.
Page 21 at the foot of the page, please. Bottom of the page. The paragraph that I've just cited from your advice is followed with the sentence, later events proved my then information and understanding to be wholly...
No, you're right, but I'm fairly sure somewhere here I made a similar point, but somewhere else.
That it was catastrophic.
Catastrophic, yeah.
Yeah. Can you please set out what you now know that demonstrates that the information upon which you were advising was wholly incorrect? Firstly, in terms of the Post Office being in possession of disclosable information.
I'm afraid I can't give you detail because it's so complicated, and my knowledge has developed over the course of the years, up to and including the appeals in March 2021. But what I discovered in later years, and by later years I actually mean the Horizon Issues trial onwards and that judgment, was the landscape, as I called it earlier, was entirely different, that it was perfectly clear to me that individuals within the Post Office were very well cited on all of the problems. Some of them you demonstrated during the course of your examination today. And, I look at paragraph 106, which I've read more than once, as a remarkable insight into my ignorance and what I wasn't told and what I didn't understand.
In terms of the Post Office being, quote, wholly dependent on Fujitsu and or the expert to reveal material so that Post Office could perform its prosecution duties, who provided you with that incorrect information?
Sorry, which paragraph is that?
It's highlighted on the screen.
Oh, sorry.
It's a citation
forgive me, it's my...
from your advice. Post Office was inevitably in a position where it was, quote, wholly dependent on Fujitsu and or the expert to reveal material so that Post Office could perform its prosecution duties? And I'm asking who provided you with that material, that information?
I just don't know, but it was clearly something that was in my mind at the time that I wrote this.
Was that, in fact, not information that was provided to you, but rather a conclusion which you drew by reading the material that you had been given? I.e., it's your subjective assessment.
Perfectly possible that it's an inference from everything I saw.
Thank you.
Or everything I was told, or perhaps not told.
That can come down, thank you. Were you told about a possible plan to transfer cases to the CPS to consider for prosecution?
What, the Post Office had a positive plan to do that?
Yes. Or was considering whether to do that?
Well, I think it was something obviously I looked at in this review document. Whether I did it off my own bat or whether somebody suggested to me, is this something we should be looking at, or further than that, there is a plan to do this, I simply can't recall.
Can we have a look at an email exchange, please? Poll 0014 7419. You'll see this is an email exchange that you're not included on. It's from Roderick Williams, litigation lawyer at the Post Office, to Chris Oyard and others, dated the 11th of January 2014. And it's a summary of what he says was his discussion with you earlier that day.
But which obviously postdates this review by a month or two.
Yes.
Yeah.
And can you see that under A, just in passing, you seem to have advised in the last bullet point, board minutes or discussions about pursuing a prosecution policy for commercial aims may need to be disclosed. If the application of that policy was ever called into account, this presents a risk of reputational damage.
And the key message beneath that?
Yes.
Yeah.
Where it records a key message, do you think that's him summarising a key message that you told him, Roderick Williams?
Well, I think it's the penultimate bullet, the one above the highlighted one.
Yeah. And so where it says key message, that's essentially something that you said or would have said to Mr. Williams.
Well, Chris, here's a summary of my discussion with Brian earlier today.
What I'm just looking at the moment is the attribution of words here and whether or not
I see.
the key message is something that is Mr. Williams setting out his key message or setting out your key message.
I suspect that's his key message, his takeout from his understanding of the advice I'd given that day.
But based on what you had advised. Yeah. I understand. And can we look, please, further down the page to B, jumping from A, status quo, to C, all CPS.
Yeah.
A change of policy is not an admission that past practices were wrong. It would still be open to someone, e.g. a conspiracy theorist, to say this did drive the change, referring to the temporal connection between the change in policy and the challenge to past prosecutions. This could lead to inquiries about the reasons for the change, e.g. requests for disclosure or questions in Parliament. It's far from certain the CPS would take on any of our cases given the budgetary pressure it's under. We should start discussions at a high level within the CPS if we want to take this on. I don't just announce that the CPS is going to prosecute criminal conduct in our network without raising it with the CPS first. We should not lightly give up or cede to another our expertise in identifying and, where appropriate, prosecuting criminal conduct in our network. Key message, jumping from A to C risks sending the wrong message to the network about how we view criminal conduct, both past and present, and losing our expertise in monitoring our network without any certainty that prosecutions would be picked up by the CPS. However, a change in policy, however dramatic, does not present a pure legal risk of challenge to past convictions. Does that accurately record the substance of the advice that you gave?
I can't say it. I can't say it does, and I can't say it doesn't. Not least because I have to say, when I looked at this email, I was not totally convinced. I was prepared to accept that I had given the advice in the conversation under A, but I looked at B, and when I first looked at it, I wasn't sure that that was what I had said. But so I can't answer that question, I'm afraid. I don't remember this conversation at all, this part of it anyway.
What made you think that it might not be you speaking in relation to the issues under B?
Simply because I wouldn't have said words like, e.g., a conspiracy theorist. I wouldn't have say that this did drive the change, referring to the temporal connection between the change in policy and the challenges to past prosecutions. That's not the way I express myself. So I looked at it, and I was not convinced that this was me. The next bullet point, far from certain CPS would take on any of our cases given the budgetary pressure it's under. I know I did have that view, and I expressed it in the review document we've just been looking at.
You saying you think you've been verbaled here?
Sorry?
You saying you think you've been verbaled?
I don't want to be unfair to Mr. Williams. There are possibilities that I had this discussion. I just looked at it. I just didn't think it reflected the way I would express myself. But, it's possible. I just don't know.
In any event, did you advise Mr. Williams that shifting cases to the CPS would, quote, risk sending the wrong message to the network?
I don't think that's something that I would say, because that was a business case, and I don't think, looking at this now, that is something that would have been within my ken or understanding. That was something I think Post Office were very keen on, about the message.
What message were they very keen on?
Well, the one you just identified about the network and postmasters understanding that we'll pursue prosecutions.
Exactly. So exactly what message were they happy or keen on being distributed to the network?
That if you have your hand in the till, we'll prosecute you.
Thank you. That can come down. Can I turn to the fifth topic then, please, which is the advice you gave about the distinctions or absence of distinctions between offences of theft and false accounting?
Yeah.
And can we begin by looking at poll 406588, please? This is your advice on theft and false accounting.
Yes.
It's dated the 8th of March 2015 on its last page.
Yep.
We just read through some of the paragraphs. First, paragraph 1, you'd been asked to advise the Post Office on my view of the equality of the offences of theft and false accounting under the Theft Act 1968, and to consider the terms of a letter sent by Post Office, the second site, on the 24th of February 2015. And then over to page 2, please.
Well, do you mind, before you do that, going to paragraph 2, because that's the information I had as to why I was being advised. It wasn't just about the letter.
Of course,
the arguments.
You were told that
Yeah.
Second Sight is beginning to advance arguments that the Post Office is abusing its prosecutorial role by charging sub-postmasters with theft when there's no evidence of it, in order only to pressurise them into pleading guilty to false accounting.
Thank you.
Then over the page, please, to page 2, paragraphs 5 and 6. You say you've been made aware that Sir Tony Hooper has seen the letter. That's a letter sent by the Post Office, the second site. And the gist of what he has said, amongst other things, is that false accounting is a lesser charge than theft. So Second Sight was not incorrect to characterise it as such. He added that, however, that if someone steals, then that is more serious than if someone falsely accounts, to cover up an accidental loss of £10,000, but if someone falsely accounts for, say, £500,000, then that offence is of greater seriousness. And then page 3, please. And scroll down to paragraph 9. You say, first, there's no legal concept of equality of offences in law. All I think Cartwright-King meant by it was that both are offences of dishonesty, carrying identical maximum sentences. This was a generalisation, but in reality means little or nothing. And then page 5, please. Paragraphs 14 and 15. You say, my point is that merely because the charges involve dishonesty and maximum sentences of 7 years, it's not to tell the whole story of how in individual cases a judge is likely to sentence one from the other. Each case involves a careful process of assessment and of culpability of the offender, harm caused, the aggravating and mitigating factors, and the individual guideline into which the offence fits. If I may say so, the so-called equality of the offences is an unnecessary and unprofitable focal point of attention. The other points raised by the letter have greater force and are defensible. And then lastly, paragraph 22 on page 7. In conclusion, I advise that both offences of theft and false accounting do indeed involve dishonesty and do carry a maximum sentence of 7 years imprisonment. I think the only argument that may be advanced to defend the statement is that it is accurate within the narrow context in which it was stated. The point is that false accounting may be a lesser offence, and may be a lesser offence in the context in which it's charged. So to argue it's not a lesser offence is not accurate. It all depends on the circumstances of the individual case, as Tony Hooper's illustrations show. The statement is undermined by the fact that the seriousness or otherwise of any offence of theft or false accounting must always depend on its own facts, as is demonstrated by the many ways in which such offences may be committed and how offenders may be sentenced for them. Do you think you really addressed the substance of the issue being raised, namely that there was an allegation or suggestions being made that the Post Office had a practice of charging theft when there was no or insufficient evidence of theft in order to pressurise sub-postmasters into pleading guilty to the lesser offence of false accounting that had been included on the indictment? And that Cartwright-King had said that Second Sight's suggestion that false accounting was a lesser offence was inexpert and wrong?
No, because I wasn't asked in that advice to address the allegation which I set out in paragraph 2. I was simply asked to address, and that's what I did address in my instructions, the defensibility or otherwise of the letter which Post Office, crafted by Cartwright-King, had sent to Second Sight.
Wasn't the point that in the context of the real world involving cases of sub-postmasters being prosecuted, an alternative charge of false accounting to theft would inevitably be a lesser offence in terms of the likely sentence?
It can be, not necessarily always. It depends on the facts. These are fact-specific issues. But I wasn't asked to state what anybody who practices in crime knows, that people will plead guilty to offences or lesser offences in order to attract a lesser sentence.
But that was the issue, wasn't it?
I didn't think it was.
You confined yourself to the very narrow question of whether technically what your client had said in a letter could be defended.
And that's what I was asked to do, Mr. Beer. If they had said to me, and by the way, Mr. Altman, do people sometimes plead guilty to lesser offences to attract a lesser sentence, I would have said exactly the same. And you will know, because there is an email, that I asked Andy Parsons, who instructed me, to find out from Tony Hooper what it was that he was saying. I wanted to understand what his complaint about the letter was. And he came back to me, he told me what Sir Anthony Hooper's complaint was about the letter, and that is what I addressed. I'm sorry, I disagree.
Were you straining here to help Cartwright King out and not advising on the obvious issue that in this context of counts charged as alternatives to each other?
No, I'm sorry, Mr. Beard, that for me is a complete misreading, and I say that with great respect, of what I was asked to do in this advice and what this advice confronted. If I had been asked to advise on the question you would like me to have been instructed on, I would have responded. And in response to your other points that I was helping out Cartwright King, I don't see how I was when you read out what I said in paragraph 22, including the point is that false accounting may be a lesser offence and may often be a lesser offence in the context in which it is charged. So to argue it's not a lesser offence is not accurate. And it's absolutely accurate, as I continued here, to say it depends on the circumstances, as Tony Hooper's illustrations showed. So forgive me, I fundamentally disagree.
And so you didn't think it was part of your function to make the obvious point?
No, because it is an obvious point, and Cartwright King would have known it, and anybody else would who practices in crime. I did not for 1 second think I was being asked to advise on that. What I was being asked to advise on is exactly what I set out, is this paragraph. In other words, have we got this right? So Tony Hooper is saying this is nonsense. Cartwright King has given us this advice, and that has been reflected in this letter. Are we right or are we wrong? And the product of my advice is in the conclusions in paragraph 22. That was what I was asked to do.
Wasn't it clear to you that Sir Tony Hooper was taking the point that it's really an irrelevance to say that the two offences are equal to each other by simply looking at whether they contain as an element dishonesty and whether they have the same theoretical maximum sentence?
No. I mean, if you want to look at the email I got, I know you have it. It's a B31. But the email I got, because I was keen to understand what Sir Anthony Hooper had in mind, if Andy Parsons had made that point to me, and if that's what had been passed on to him, then I would have given the advice, of course. It is a lesser offence, and it's one to... And anybody in any environment will often plead guilty or offer a plea of guilt to what they perceive to be a lesser offence. I would have said it plainly. Of course I know that to be the case. I've been in practice for over 40 years. But this was not what I was being asked to do.
Let's look at tab B31, poll 00125777. And we look at page 2, please. At the foot of the page, email from you to Andrew Parsons in the run-up to giving this advice. Third paragraph. In the meantime, one question I have for you is I'd like some expansion, if you can get it, of precisely what Tony Hooper said. The equality of offences is not actually a criminal legal concept, although I understand what this is really all about. What did you mean when you said, I understand what this is really all about?
It was all about a letter. It was all about a letter which had been sent by post office on the advice of Cartwright King to Second Sight, about which Tony Hooper had issues. That's what it was all about.
Aren't you saying there that it's not the technical issue of the maximum sentence of imprisonment or whether they contain both offences, a requirement to prove dishonesty? I understand what this is really all about, meaning sub-postmasters being pressurised into pleading guilty to a lesser offence, and lesser in that context.
No, because you need to read the next sentence.
What I'd like to know is what Tony did say, how he expressed himself, etc. And then if we go, please, to the reply. Page 1, please. Foot of the page. Brian, Tony's comments were, I don't know where you, Post Office, are getting your legal advice from, but it's wrong. False accounting is a lesser offence than theft. That's what you concentrated on, didn't you?
That's exactly what I did concentrate on, because that's what I thought I was being asked. It was all about, if you go back to the advice, it was all about Cartwright King, and you didn't take me to this actually, Mr. Beale, when we went through my advice, but it's paragraph 6 and then paragraph 7 of the advice. That's what this was all about. Paragraph 6 in its advice.
Hold on.
Sorry.
Mr. Altman,
It's POL.
it's all right, I can give the reference.
All right.
Poll 406588. Second page, foot of. I think you wanted to read paragraph 6. Didn't you?
Yes. In its advice, CK had said that SS's views were inexpert and wrong. On this particular topic, they said, the suggestion that the offence of false accounting is a less serious offence than that of theft. This suggestion has appeared in a number of contexts, most commonly where an applicant has pleaded guilty to the former offence so as to avoid the more serious charge of theft, or has pleaded guilty to the lesser offence of false accounting. And then please to the next bullet point.
Over the page.
In fact, both offences are equal in law, both are offences of dishonesty, both carry the same maximum sentence, 7 years imprisonment. And then paragraph 7, this was used as the basis for a letter that was sent to Second Sight, which included the statement, the suggestion that the offence of false accounting is a less serious offence than that of theft is incorrect. Both offences are equal in law, both are offences of dishonesty, and both carry the same maximum sentence. That's what I was addressing.
Just look at paragraph 8, please.
Yes, is defensive.
Scroll down, please. Bullet points 1, 2, and 3 focus on the statement.
Yeah.
Bullet point 4 asks you whether, in your view, it's fair to characterise these offences as being equal against whatever yardstick you think is most appropriate.
Yeah. Well, I'm afraid if Mr. Beale, with respect, you're saying that was some Delphic suggestion that I should be looking at the points you're making, then it passed me by. I was looking at the defensibility or otherwise of that letter.
So you thought your task was just to look at the very narrow issue of
absolutely.
defensibility?
I did, I'm afraid. I did.
Can we move to a separate topic then, please, Mr. Altman, the legal advice that you gave in relation to disclosure? That can come down from the screen, thank you. Beginning by looking at poll 0012-3003. And if we just scroll down, please. Yes, sorry, just scroll back up, please. It's that sentence, or that paragraph 3 from the bottom, beginning Brian Altman, QC's first review has now been received. If we just go to the top of the page, please, to get the context. It's not a chain you're copied in on. It's dated October the 21st, 2013, from Andrew Parsons to a range of lawyers and Belinda Crowe. Back down to where we were then, please. Brian Altman's first review has now been received. We've seen that. The first review looked into Post Office's compliance with its prosecution duties in the light of Second Sight's finding. In particular, it considered the Post Office's legal duty to ensure that the Post Office's findings were fully disclosed.
Second Sight's findings?
Yes, fully disclosed to any person who's currently being or has previously been prosecuted by the Post Office. You concluded that the Post Office is complying with its duties and that the approach adopted by the prosecution team was fundamentally sound. This report gives the Post Office good grounds to resist any formal external review of its historic prosecutions, i.e. by the CCRC. Had you in fact advised that your advice or report or review gave the Post Office good grounds to resist any formal external review of its historic prosecutions?
No.
Was there discussion with you after the production of your review that was how the Post Office was going to treat it, that it gave good grounds to resist any review by the CCRC?
No, no, absolutely not. Not least because this email, as you just pointed out, is dated the 21st of October. We've looked at my work log, and I think the last conference I had was the 4th of October.
Was that an accurate statement of the import of your general review advice?
No.
Was that ever discussed with you, that the review was viewed by the Post Office as a weapon, a shield or a sword to resist any oversight or investigation by the CCRC?
No.
And you didn't see it that way?
I certainly didn't see it that way, and I never saw this.
Can we move forwards, please, to February 2014, poll 302-1750. And can we start on page 3, please? On page 3, we should see a series of questions to you of the 27th of February 14 from Andrew Parsons, the then senior associate at Bond Dickinson. He attaches a report in Mrs. Brewer's case, and at the end of the report, Second Sight draw the following conclusion: that whilst we've not been able to establish a direct causal link between communication line problems and the losses reported, we believe that communication line problems did play some part in these losses. Post Office would be grateful for your thoughts on whether this type of comment is of a type that would be disclosable in other past or future criminal cases. Appreciate this is a broad, very broad hypothetical question, and that disclosures need to be considered on a case-by-case basis. We're looking for a steer on whether this type of general unevidence view could ever be over the disclosure threshold. And then if we look at your reply on page 1, scroll up, please. Sorry, page 2, scroll up. Thank you. You say, dear Andy, in principle, the comment found in 5.1 would, I'm afraid, prima facie be disclosable in any case involving assertions by a defendant that there was some causal link between communication lines.
It says casual, it should have been causal.
Yes.
Yeah.
And reported losses. The fact that Second Sight's view is unevidence would not alter its potential disclosability as such. And then if we go to the bottom of the page, please. You say the best result for now, last paragraph, would be a concession from Second Sight, that this is a conclusion that's specific to this case only and does not apply across the board, unlike, for example, their conclusions in their 8th of July report. Whether Second Sight might be prepared to concede that remains to be seen. Then over the page, were they not to soften their stance and stand by their conclusion, then we may have a problem. You might then have to think of whether there's any other expert Post Office might instruct who could undermine Second Sight's opinion on this. How realistic in practice this is, and politically, only you will know. And then page 1, please. Foot of the page, please. Mr. Parsons, you're not included on this, distributes your advice. Please see below from Brian Altman, read the comms issue in Second Sight's report. Brian's view is the Second Sight statement is probably disclosable to other prosecuted or convicted sub-postmaster in a similar situation. My view is we're unlikely to make Second Sight change their opinion. Next paragraph, that's not to say Post Office should not challenge Second Sight's conclusion. We should be getting Fujitsu's view and assuming it's strongly supportive, giving it to Second Sight. Fujitsu's analysis can be deployed at mediation and may, subject to Brian's further thoughts, prevent the need for disclosure, mitigate the impact of the Second Sight report in criminal proceedings. When you gave your advice, you began by saying, I'm afraid that this is disclosable. Why were you afraid?
It's just a term that I use.
Were you softening your response to the Post Office by using that phrase?
Softening my response?
Yes, by saying, look, I'm on your side, but I'm afraid I've got to give you some unpalatable advice.
I don't think so. It is, I'm afraid, a term I use an awful lot, and I just used it there. I mean, I'm very colloquial in the way I write, and I suspect that's all it is.
You came up with ways in which the Post Office might be able not to disclose this information to other convicted defendants.
No, I don't think that's fair, actually, Mr. Beer. What I was saying was, before disclosure in cases that may arise, that's the second paragraph, that you should, as it were, hammer this out with Second Sight and find out if it's an expert rather than an inexpert opinion and see what those discussions bring. That's all I was saying. I did not soften my approach to that, and I did not say that this should not be disclosed. I said before disclosure in respect of any cases that may arise. So in other words, I had already given the advice that it was prima facie disclosable, but that a Post Office were entitled to know what the issue was, whether it was a matter of expertise, and whether the expertise suggested by Second Sight was expert or inexpert. That's all I was saying.
You said the best result for now would be a concession.
Yes.
This is case specific.
Yes.
Can we move on then, please? Seventh topic, Mr. Clark's advice of the 2nd of August, 2013. Can we look, please, at that to remind ourselves of it? Poll 406799. I'm not going to go to the last page because it will take too long, but we know this is dated the 2nd
of August, yeah.
And this was sent on to you, wasn't it?
I'm sure I saw it, yes.
And can we look, please, at page 2, please? At paragraph 5, to see the information on which Mr. Clark was basing his advice.
Yep.
After the call on the 31st, the following information was relayed to him. One, the minutes of a previous conference call had been typed and emailed to a number of people. An instruction was then given that those emails and minutes should be and have been destroyed. The word shredded was conveyed to him. Handwritten minutes were not to be typed and should be forwarded to the Post Office head of security. Advice had been given to the Post Office, which he relays verbatim as, quote, if it's not minuted, it's not in the public domain and therefore not disclosable. If it's produced, it's available for disclosure. If not minuted, then technically it's not. And then Roman 4, please. Sorry, we go up. Thank you. Some at the Post Office do not wish to minute the weekly conference calls. Can we look, please, at poll 406803, which is your general review? And look at page 36, please. And paragraph 111 at the foot of the page. Under other initiatives, you say, I've been provided with an advice written by Simon Clarke, dated the 2nd of August. That's what we've just been looking at, in which he advised on the question of disclosure and Post Office's duty to record and retain material. In it, he confirmed advice he'd given Post Office at a meeting at head office on the 3rd of July that there ought to be a single central hub, the function of which was to act as the primary repository for all Horizon issues. The hub would collate from all sources into one location all Horizon-related defects, bugs, complaints, queries, and Fujitsu remedies, thereby providing a future expert witness and those charged with disclosure difficulties with recourse to a single information point where all Horizon issues could be identified and considered. The rationale behind it is to put in place a mechanism to protect the Post Office from future such issues. In the result, a weekly Wednesday conference call meeting has been established. To meet the requirement, attendees are expected to bring all Horizon-related issues to the meeting and minutes are kept. However, early teething and, in inverted commas, cultural problems arose as highlighted in Simon Clarke's 2nd of August advice, and indeed to me in Harry Bowyer's response to my interim review. You refer there to what Mr. Clarke had described about an instruction to destroy or shred minutes as an early teething or a cultural problem. Is that how you saw it, a teething issue?
I'm not sure necessarily the teething applies to that part of that advice, but the word cultural, you'll see, is in inverted commas. And I think that refers back to the conference I had on the 9th of September 2013, where you will see it referred to as cultural.
Yes, Susan Crichton said that there had been some cultural problems.
No, I think it was Simon Clarke, actually.
Okay.
Not Susan Crichton, because there's a he that comes afterwards. So it was Simon Clarke who was referring to it. And he also said in that September conference that it had been overcome. And so...
What were the teething problems you were referring to then?
I can't remember. But the cultural problems were certainly, I think, was it John Scott?
The head of security?
Yeah, head of security, who had come up with some ridiculous suggestion, as you've just read out to me, and reminded me of in the 2nd of August advice. I don't know what conversation we had about it during the 2nd of September conference. I'm sure we did, but I had been assured that that had been overcome. I think that's the word that's used, and I moved on.
So you're saying that the teething and cultural problems are referring to something other than the destruction or shredding of minutes?
No, I think the cultural problems refers to the allegation or the idea that Scott had that minutes should be destroyed. I don't know if early teething refers to the same thing or something different. I think
Hold on, just if you look at that sentence has footnote 36 against it. Can you see?
Yeah. I can't see the footnote at the moment.
Yes,
it
if
says
you go
paragraph
down
five,
to
paragraph 5.
Paragraph 5.
Yeah,
exactly. Which is the paragraph I read to you.
Well, maybe I did refer to it in that way, but that was not to be dismissive of it. It was clear to me, in bearing in mind the date of this is the 15th of October, I'd been told 5 weeks earlier that the problem had been overcome, and I may also have understood by them then that in fact nothing had been destroyed or nothing had been shredded, despite the content of paragraph 5 of Simon Clarke's 2nd of August advice. And that's why I didn't deal with it at any length here.
Was the suggestion of the shredding of evidence made by the head of Post Office Limited Security, head of security, where that evidence related to bugs, errors and defects in Horizon, a teething problem?
I'm sorry, can you take me back to paragraph 5 of Simon Clarke's advice so I can just see that again?
Exactly. Poll 406799. And over the page. And it's paragraph 5.
Sorry, where does it say bugs, errors and defects?
That's what I'm asking.
Yeah. No, I mean, this all dealt with, this all related to the Wednesday Hub meeting.
The purpose of which was to
collate issues.
About?
Yes, of course, I get what you're saying. But I had understood all this time later that it was a proposition put forward by John Scott, which had, and it had been dealt with swiftly. And he'd been told in no uncertain terms that that would not happen. I also understood that that had not happened, and it had been overcome. Maybe it's an unfortunate choice of a word, but I didn't mean to dismiss it, as I said already.
You would agree that the word a teething problem, when the head of security is suggesting that evidence should be shredded, is something a little more than teething, isn't it?
I accept that.
Were you made aware, that document can come down, thank you, of any investigation that had been conducted by Post Office into the allegation made against Mr. Scott?
I understood, as I've just said, that the issue had been overcome, so I assumed there had been and he'd been spoken to.
What did you understand had happened in order to overcome the issue?
I can't remember now.
Was the essence of it that the problem had been squared away?
Had been...
Squared away.
I'm not quite sure I understand that term, what that means, squared away.
He had been spoken to. He had apologised. He had said that he wouldn't do it again, or some other form of...
I assume he'd been given words of advice that this is not what happens and it won't happen in the future. But I can't remember. I'm sure there may have been a discussion about it, but I can't remember what was done about it. But as I keep on saying, I knew by the 9th of September whatever had happened and whatever he had said had been overcome.
Did you give any consideration around October 2013 to the issue of whether an instruction by the head of security to destroy or shred recorded information concerning Horizon issues failed to be disclosed?
No, I didn't.
Can we turn to my eighth topic then, please? Legal advice in relation to the CCRC. Can we start, please, by looking at poll 304-0046? An email to you of the 23rd of October 2013 from Mr. Matthews. Subject, CCRC draft letter. As mentioned at yesterday's meeting with, with Chris Oyard, I attach a proposed letter to the CCRC in the light of the fact that you've now completed your review of past and current prosecutions. Leaving aside the fact I've drafted it to be sent by Susan, please can you review and amend it? I'm not precious about my drafting. And can we look at the attachment, please? Poll 304-0047. It's a one-page letter to the CCRC. Second paragraph, I'm now in a position to confirm that Brian Altman, Queen's Counsel, has completed his review of the Post Office's strategy and process for reviewing past and current prosecutions, given the findings of the Second Sight interim report. I'm now in a position to give you an update. As you'd expect, Mr. Altman's review has been thorough, leading to a detailed report. I'm pleased to confirm that overall his view is that the review is fundamentally sound and he's not detected any systemic or fundamental flaws in the review process or in the evidence arising from it. He has, however, highlighted that because the review is a continuing process and the Post Office has a continuing duty of disclosure. Both Post Office and the external firm of solicitors must be prepared to keep under review and reconsider past cases and disclosure decisions. To give you detail, the process involves reviewing all cases going back to the 1st of January 2010, this being the earliest date on which Horizon Online was migrated into all Post Office branches, and is a start date which Mr. Altman's Queen Counsel considers to be logical, proportionate and practicable in the light of the known circumstances. The scheme involves the Post Office's solicitors identifying every case within the above-mentioned review period in which the primary or main evidence against the defendant was based on Horizon data. This is done by a SIFT review process. Once a case is identified, senior in-house prosecutors at the solicitors carry out a full case review to determine the question, quote, had the Post Office been possessed of the material contained within the second sight interim report during the currency of any particular prosecution, should or would Post Office have been required to disclose some or all of that material to the defence? And then some statistics are to be set out. Would you agree that the description of your review is very much put at its highest there and lacks all of the caveats which you yourself placed on the Post Office review of its continuing disclosure duties?
Well, it doesn't set them all out, I agree with that. And it does tend to put it at its highest, or at least is an attempt at a summary.
Of course, there's no mention about the concern over the integrity of Mr. Jenkins' evidence.
No, I can speculate why, but I suspect because Gavin felt that this was a letter that was going to the CCRC about historic cases, but I also, in other words, that Gareth Jenkins' taint going forwards, that he would not be used, was not in this letter, but I take the point, if by it you mean, it should also have referred to that fact.
This was the occasion, this might be the 6th occasion I've asked you about it, in which that very issue ought to have been mentioned.
Yep, I agree.
And there's no reference there to the Helen Rose report either, is there?
Well, I'll take it from you. There is a reference to the second sight interim report, but not to that, no.
Do you know why that is?
I've no idea.
Was the impression ever conveyed to you that in relation to the Helen Rose report, from the Post Office's perspective, the least said is the soonest mended?
No.
So can we take our afternoon break there, please, until 3 o'clock?
Yes, of course.
Thank you very much, sir. Afternoon, sir. Can we continue, Mr. Altman, by looking at the disclosure to the CCRC issue, which is my 8th and last topic? Can we turn to 2014 and look at poll 00124350? This is a letter dated the 5th of June 2014 to the CCRC. If we go over the page, please. We can see it signed off by Chris Oyard. And then if we go up the page to page 1, please. He says to the CCRC, in the first paragraph, some apologies over the lack of an update. Second paragraph, I confirm that Brian Altman QC completed his review of the Post Office's strategy and process for reviewing past and current prosecutions, given the findings of the second sight interim report, to which Susan Crichton referred in her letter to you dated the 26th of July 2013. That's the draft of which we've just looked at. As you'd expect, Mr. Altman's review was thorough, leading to a detailed report. I'm pleased to confirm that overall his view was that the review was fundamentally sound and he did not detect any systemic or significant flaws in the review process or in the evidence arising from it. He did, however, highlight that because the Post Office has a continuing duty of disclosure, both the Post Office and the external firm of solicitors with vast experience of managing and prosecuting these cases must remain prepared to keep under review and reconsider past case reviews and disclosure decisions. To give you some detail, the process involved reviewing all cases going back to the 1st of January 2010, etc. Essentially, the scheme involved Post Office solicitors identifying every case within the above-mentioned review period in which the primary or main evidence against the defendant was based on Horizon data, and also included those cases involving suggested problems with Horizon training or support. This was done by a rigorous SIFT review process, and then an escalation to senior counsel. Then over the page, please. This involved Post Office's external solicitors carrying out a SIFT of 308 cases, a second SIFT of 229 cases, a full review of 53, in which disclosure was advised in 26, and discontinuance of 4 cases. I can confirm that since the publication of the Second Sight interim report, and despite the Post Office's thorough review, it hasn't received any application for permission to appeal. Were you aware that the Post Office intended to pray in aid your position with the CCRC when it was writing to them like this?
When you say my position, by what you mean?
I.e. the conclusions of your general review.
I don't know what I knew. I can't say now, at this distance in time, whether I saw this letter at the time or not.
That was what I was going to ask. Were you given the opportunity to input into this, to the letter that was eventually sent on the 5th of June 2014?
I really can't say one way or the other.
And so you can't help us whether the description of your conclusions here, which again lack some of the caveats that we've seen in your general review, was something that you had the opportunity to point out.
I can't, but not to be unkind to Mr. Ojard, if you look at the final paragraph, I appreciate the above is a short précis of a very extensive procedure, and should you have any further questions, don't hesitate to comment. So, I mean, he left open to the CCRC to come back with further questions, I suppose, is all that can be said.
And so if we go to poll 0015-8047, sorry, poll 0015-0847, thank you. This is the CCRC's letter of the 14th of January, and if we scroll down, it's a requirement to produce materials. I write in relation to ongoing correspondence, your most recent letter was dated the 5th of July. That's what we've just read.
5th of June.
5th of June, I'm so sorry. We've just read. Then there's some standard text. It's considering the situation regarding the Horizon system and the associated criminal proceedings. The Commission requires you to identify all documents and materials in your possession relating to this matter and to produce them. Specifically, the Commission requests a copy of Brian Altman QC's report. Yes? And it encloses a notice under Section 17 of the CAA 95 requiring the Post Office to do this. Do you remember this development?
I'm sure I must have done.
Do you remember there was a conference in Chambers with you at the end of January 2015 to discuss the CCRC's request for a copy of your general review?
Yes, I'm fairly confident that must have happened.
Can we look, please, at poll 0015-1181? This is the reply to that letter.
Yeah.
And it seems a chase call on the 27th. The Post Office has had the opportunity to consider fully the letter, and then scroll down. the author notes that the Commission is now considering, this is Jane McLeod, incidentally, the author of this letter, the then General Counsel. The Commission is now considering the situation and notes that the letter and notice specifically requests a copy of Brian Altman QC's report. Background. We trust you'll appreciate that the request you make is with respect wide and in the most general of terms, notwithstanding the specific request for Brian Altman QC's report. I've reviewed the previous correspondence. I summarise that correspondence as follows, and then she summarises some correspondence. That page, and if we go over the page, please. And then scroll down. And then under Poll's position. Having considered the position more fully against this background, I'm unfortunately currently unable to see how the request you make fits within the guidance of paragraphs 4 to 6 of the Commission's formal memorandum, the Commission's power to obtain material from public bodies under Section 17 of the Act. This is especially so given that Mr. Altman's report does not address individual cases, but rather the Post Office's strategy for reviewing past and current prosecutions generally. The Post Office continues to assert that LPP attaches to Mr. Altman's report whilst remaining aware of its duty under Section 17. Further, the position on individual cases remains that in respect of the cases which are prosecuted, it has not been made aware since the publication of the Second Sight report of any applications having been made for leave to, over the page, appeal. And then the rest of it concerns, there's a sentence which says the Post Office nonetheless wishes to emphasise that it wants to and will work with the Commission. Was it the conclusion of the conference that you had at the end of January that the Post Office should maintain or assert privilege in respect of your general review?
I can't remember what happened in the course of that conference, but undoubtedly the general review was legally privileged, but of course that didn't disentitle the Commission from having sight of it.
No. Did you form a view at the time that the Post Office was, on the one hand, praying in aid your conclusions in correspondence with the Post Office, with the CCRC, and with the other saying you're not entitled to see those conclusions?
No. I mean, first point, as you've demonstrated, yes. Second point, no. I think all that this letter demonstrated is that the Post Office wanted to be absolutely clear on what basis my review was going to be disclosed to them under the notice.
It doesn't say that, though, does it? It doesn't say we need clarity as to the basis on which...
Oh, I think it does, because if you go back to the previous page at the bottom,
yes,
isn't Jane McLeod talking about the memorandum? And if my memory serves me, doesn't the memorandum say that the Commission can only ask for or issue a notice in relation to specific cases rather than a sort of generic notice? I think that's all that was being said here.
So why was the Post Office deploying your advice at all then to the CCRC?
Well, that I can't answer.
I think by 2015, it's right, isn't it, that you had taken a different position to that of Cartwright King on a number of matters?
I would have, or I did.
You did. You had taken a different position to them on a number of matters.
I think so, yes.
Were you aware of whether or not by this time the CCRC had been sent a copy of the Clark advice of July 2013?
Well, we know now that they never were. Your question is more focused as
yes.
to whether by that time I didn't.
Can we move on, please, to poll 0022 359?
While that's happening, I take it from an earlier answer, Mr. Altman, that despite this letter, shortly thereafter, your report was disclosed to the CCRC.
Yes, 27th of February 2015.
Yeah.
Cross-reference for that, sir, is poll 00151296 for the transcript.
Yeah.
27th of February, 15. This is an agenda for a conference with you on the 27th of March 2015 within a project or Operation Sparrow.
Yeah.
You see the heading there.
Yeah.
And you're one of the people to whom this agenda is distributed. Please find below agenda at Finsbury Dials. And then topic 4, approach to / obtaining comfort from pre the 1st of January 2010 prosecutions. Do you remember a conference in which the Post Office wished to obtain comfort in relation to pre 1st of January 2010 prosecutions?
I'm afraid I don't even remember this conference, let alone the agenda, and I can only speculate what point 4 was about. But looking at,
Can you help us?
it's a pure speculation. But looking at the date, the 26th of March 2015, bearing in mind that my general review was at the back end of, or the autumn of 2013, we're talking about 18 months on from there. And as far as I know, nothing had changed in terms of information. It may be, I don't know, that the CCRC had asked questions about the cut-off date, the 1st of January, and maybe I was being asked to advise whether it was still appropriate and proportionate and all the rest of it. But to my mind, my knowledge of bugs did not change. In fact, it didn't change until the Horizon Issues trial. So that's my speculation.
Can we look lastly then, please, at what might be a handwritten note of the conference?
All right.
Poll 00155545. Poll 00155545. Can you see a date in the top right-hand corner
Yep.
of the 27th of March 15, which corresponds with the date set out on that agenda?
Yeah, and whose note is this?
I don't think we know.
Oh.
I mean, it looks similar to some writing that we've seen elsewhere, but I'm not going to turn myself into a handwriting expert.
No.
Can we see 2/3 of the way down the page, please? If you just pan out, please. Yeah, sorry, it's about halfway down the page. Next to CCRC. Can that be highlighted? CCRC sets out statement of reasons, goes to the Court of Appeal. Defendant has own representation. Does that sound like the kind of thing you might have summarised in a conference about the process?
Yes, if I'd been asked about the process to remind them, I would have said this.
And then Court of Appeal, miscarriage because error in conduct, judge made error, new evidence, point of law. I should have said misdirection or ruling against judge made error. So a summary of some of the grounds
Yes.
on which an appeal might be contemplated or even allowed.
Yes.
And then scroll down, please. And then underneath the two horizontal lines, look at Horizon, sufficiently reliable question mark. If not, what happened in the particular case? Can you help us as to whether that was you speaking, and if so, what you might have been saying?
Can we just zoom back out so
Yes.
I can see the whole page? Because I'm just questioning. I don't know. If you look at the style of the note, it begins with arrowed bullet points, and then, as you point out, it's got the two horizontal lines, and then 2 points 1 and 2. So, if we assume that this note is still part of the same conference note of the 27th of March, and if we assume that this was me asking questions, then I think the answer to your question, Mr. Beer, is in the words which are written there,
Okay.
if that makes sense.
If we scroll down a little further, please. At the, up. At the foot of the first page,
Yeah.
in capital letters, this is what we've got. It's not everything. Can you help us with any context as to in which that might have been discussed?
Really not. I mean, I wonder if the document handler would kindly zoom out of that again so I can see where it fits on the page, but I'm not even sure if this is not a note to self by the
author.
By the author.
The passage under the two horizontal lines, look at horizon,
Yeah.
sufficiently reliable. Was there any discussion in March 2015 to which you were a party over whether or not the Post Office needed to look again at whether horizon was sufficiently reliable?
Well, just basing myself on the history of my instruction, and obviously you understand that I wasn't working on Post Office every day of every week, far from it. In some years, I popped up for individual instruction and then went away for weeks or months, obviously doing other work and other professional commitments. So to answer your question, look at horizon sufficiently reliable, if not what happened in the particular case. I cannot remember after March 2015 until I was asked to do a further review in 2016, other than I'm sure the odd email, possibly a conference, that anything of any substance of that nature was ever put my way.
Thank you. Thank you, Mr. Altman, for answering my questions.
Thank you, Mr. Beer.
So I think there are three core participants who wish to ask questions in the order of Mr. Steen, Ms. Patrick, and then Mr. Henry.
Right. And is approximately 15 minutes each sufficient for them, Mr. Beer?
Absolutely, in particular, because Mr. Steen said he would be 10 or 12 minutes.
Right. Well, as you know...
I thought that I was going to be 20. I told Mr. Beer that. I hope you could forgive me if I'm given 15, I might go to 20 because I have a bit of material to put to Mr. Altman.
All right, we'll see how we...
Thank you.
Mr. Steen, let's see how accurate you can be.
Yes, sir, thank you. Mr. Altman, can we just help everybody understand what it means by being Senior Treasury Counsel and First Treasury Counsel? Now, these are terms that we're all used to, those of us that practice in criminal law. Senior Treasury Counsel, your work is engaged with reviewing both that's before and after charge, serious cases that are brought to you. Is that fair?
It can include that work.
Yeah, and it includes advising on such cases that are brought to you so that you can advise in relation to the way that investigations are being conducted, and thereafter investigations continue once an individual is charged. Is that right?
Yes, it can include that.
Yeah, and the work that you've done in that role as Senior Treasury Counsel, then First Senior Treasury Counsel, would have included the most serious of cases that are prosecuted or considered for prosecution within England and Wales. Is that right?
Yes.
Okay. You would have been used to advising on sensitive cases, in other words, cases that carry issues that relate to the different types of police services. Is that also correct?
By which you mean?
Well, sensitive issues that relate to matters that might be covered by PII.
Yes.
Yeah. and you're trusted to consider those cases, those most serious of cases, and give advice as to their progress, yes?
Yes.
All right. So simply put, you're used to dealing with serious, complex, big cases and advising as to what you believe should happen and what would be the right thing to do.
Yes.
Okay. Now, just help us a little bit more. Your position is set out somewhat by some quotes from various, I think, directories that deal with barristers, and some of those quotes are set out on your website. You're described as being one of the greats of the bar. That's one of the quotes. Do you remember that?
Was somebody has said that of me in a testimonial on the website. Yes,
That's right. It's on the website for Chambers.
Yep.
It also describes you as being a brilliant operator.
Yes.
That's also on the website for Chambers. Now, let's then turn to how that helps us understand what happened here. Now, the CPS is an organisation, the Crown Prosecution is an organisation that considers and engages in the prosecution of serious cases where people may go to prison. Do you agree?
Yes.
The Post Office at the time that you were first instructed was also an organisation that engaged in the consideration of and prosecution of serious cases whereby individuals may go to prison.
Yep.
Yeah. You've described in the evidence that you've given to Mr. Beer that you didn't address your mind in any of your advices or your review to your ethical position. In other words, you didn't set out that you're following the ethical guidance for advocates within the CPS. You didn't refer to that as an example, did you?
I don't think that was the question I asked. I was asked. I think the question I was asked was whether, because I was acting for a commercial organisation, I was following the same ethics. He did not ask me, as I recall it, whether that was or should have been set out in my general review or any of the advisory work.
Well, I'm sure Mr. Beer would apologise for not asking that direct question, but help us please understand what ethical guide were you following when advising the Post Office?
With the same ethics I always employed, Mr. Steen.
Well, as someone that is a prosecutor, that guidance, or as a member of the bar, which?
Well, both.
Right. Now, you use the term Minister of Justice. That's perhaps a short form way of describing the ethical standpoint of a prosecutor. Is that fair?
But it was targeted in this particular case at the Post Office as a private prosecutor.
Right. Does that mean that your advice was any different, do you think, to Pole as a private prosecutor versus, say, the CPS if you've been asked to look at similar things?
I don't think so, no.
Right. So you applied the same ethical standards to the work that you did for the Post Office as you would have done for the CPS?
I'd like to think so, yes.
Or did you?
I'd like to think so, Mr. Steen.
Well,
yes.
you've had plenty of time to reflect upon this question. Did you apply the same ethical standards
Yes.
to the work that you carried out for the Post Office?
Yes, Mr. Steen.
As you would have done for the CPS?
Yes, Mr. Steen.
And you applied the same professional standards, in other words, professional standards of competence, to the work you did for the Post Office as you would have done for the CPS. Is that also the same?
Yes.
Okay. Now, what's your first duty as a barrister?
Well, there are many core duties as a
Yeah.
barrister.
What would you say your first duty is? What, generally speaking, do most barristers say is their first duty?
Integrity, independence, doing the best for your client.
What about duty to the court?
Of course.
Of course. How far do you rank that? Do you say that that's your first duty, or does that come somehow second after a client, as an example?
No.
Right. So where you've got an issue that relates to your duty to the court versus your duty, in this case, to the Post Office, which goes first?
Well, the duty to the court is the duty that you have when you are an advocate. And I was not an advocate for Post Office until I appeared in the criminal appeals. The duty to the court is not to mislead the court. The duty here, which I'm talking about, and these are other core duties, are integrity, independence, and the other core duties which appear in the BSB handbook.
I thought we'd gone through these questions that related to your ethical approach to matters for the Post Office. And I thought that you'd agreed that you were carrying out this.
You're putting to me, Mr. Steen, what the hierarchy is. The duty to the court can't apply until you're in court, and I wasn't in court on behalf of the Post Office until I appeared in the criminal appeals.
Right. Well, let's think about how that worked out in practice. We've got the position that's set out by Mr. Clark as regards Gareth Jenkins, and that you summarise in your statement at, I think it is paragraph 26, subparagraph 5, page 13 of your statement. I'm happy for it to go on the screen, or I'll deal with it directly. Yep. You're addressing the questions that arise in Mr. Clark's legal advice, and you put it this way: why Mr. Jenkins had failed to reveal in his witness statements or evidence the bugs or defects he knew about was not a matter for my review. Okay, that's what you say there.
Yes.
So you're saying there, and accepting in evidence, as we understand it, that you were of the view that Mr. Jenkins had failed to set out all he knew about bugs and defects in his statements and in his oral evidence, yes?
Yep.
Right, okay. So you accept that Mr. Jenkins, on the basis of that understanding, had misled the court. Do you agree?
He had, yes.
Yes, okay. Help us understand a little bit, therefore, about what you did about that. Did you, as an example, suggest in your advices that the Post Office really needs to rectify this misleading of a court? Did you do that?
What do you mean by rectify?
Well, go to the court and say, this is what's happened, this is what we believe has occurred, Mr. Jenkins has misled the court.
No.
Did you advise that to occur?
You know I didn't, Mr. Steen.
Right. So we get to the point, is this correct, Mr. Altman, that you knew that had happened, but you decided not to try and rectify the misleading problem?
No.
Is that correct?
No.
Well, help us understand, Mr. Altman.
Will you let me give an answer, please, Mr. Steen?
I did. You said no. So help us understand what you did about that problem.
The evidence I have given is I did not apply my mind at the time to revealing or disclosing or advising on disclosure of the taint by Gareth Jenkins for the reasons I've given. What you're suggesting is I applied my mind and made positive decisions or negative decisions. I didn't. You won't find a single word unhappily about it in the general review.
You say unhappily because you recognise that obviously something should have been done. Is that fair?
I have conceded and I've accepted on several occasions when Mr. Beer asked me the question that what I should have done is I should have advised consideration of the disclosure of the fact that Gareth Jenkins was tainted, and that his assessment, or the assessment of him as an expert by Cartwright King and me, was disclosable and should have been disclosed in suitable cases.
Mr. Altman, what would you have done if the situation had been that you were working as Senior Treasury Counsel, advising the CPS, and within an investigation that's brought to you, the police officers tell you, look, we've got this expert, we've used him in the past, we're thinking about using him this time, but actually it turns out that we think he's bent. And the reason why we think he's bent is we think he's frankly not told the court the truth in the past. What would you have done in that situation, advising the CPS about that expert?
Well, I mean, with the sort of clarity of the question that you have just posed to me, Mr. Steen, I would have said we can't use him.
Yes.
And what is the CPS doing about past cases?
Yes. And what about perhaps an investigation into that particular expert, that person that has provided that evidence to the court? What would you have said about that, Mr. Altman?
I don't know. I'd need to understand what the specifics were in the actual case.
Well, let's make it simple, Mr. Altman. The same situations you had here arising in a CPS case, you would have said this needs to be looked at with care and investigated. Do you agree?
Well, I would have certainly have gone to the CPS and say, frankly, I would have said, you deal with this. You need to look at what's happened. You need to turn out all the cases he's been involved in. If you're talking about a police investigation or an internal investigation, I'm not entirely sure. But it might have come to the same thing.
But you didn't do that here.
No, I didn't.
Right.
I think we've actually established that many hours ago now. And Mr. Steen,
yes,
your time is running out, so to speak.
I recognise the clock and the sounds are going through. We have recognised that. And you've explained that you're frankly tired of people asking these questions.
No, I haven't said that, Mr. Steen. No, I haven't said that, Mr. Steen. I have made my position perfectly clear every time that Mr. Beer has asked me.
Why didn't you? Do you now, after all of this time, have any reason that you can give why someone who appears on the face of it to have straight misled the court, you did nothing about it? In other words, you allowed it to continue. Can you explain it?
No, I didn't allow anything to continue. I'm human like the rest of us, Mr. Steen, probably including you. And I make mistakes, and we all make mistakes. And as I said earlier, I would like to say it was misjudgment. I don't think I made the judgment about it. It passed me by. I don't know why I didn't see it. It's regrettable, and I regret that I didn't.
Was it a failure of duty?
No, absolutely not, because a failure of duty imports a positive conscious decision not to do something. My point is, the general review contained 50-odd pages of just about every thought I had, and I record everything. And the fact, actually, when I came to look at this and I realised that I hadn't said it in recent weeks, I was flabbergasted, and I can't understand putting myself back all of those years why I didn't, but I didn't. And so it was a mistake, it was a genuine mistake, but any inference that anyone chooses to draw that I made a conscious decision not to do it is wrong. And it's also wrong because the CCRC had the general review in February 2015. That's not mitigation, and I'm not making an excuse, but I make mistakes like everybody else. I'm not perfect, and I did my best with the resources I had here. I didn't have prosecuting authority like the CPS or the SFO around me to help me in the decision making.
So you say a failure of duty only applies if you make a positive decision to either look at something and then not consider it.
No,
What about just simply failing to do something, Mr. Altman?
No, I think, no, you can't, you can fail in your duty, but the duty sometimes has to have a motivation or intention behind it, and I think you're imputing that to me. That's my take on your questions to me, and there was none.
Okay, let's move on, as I've got very little time left indeed, if any at all. You've directed yourself to the question, which is you've learnt matters that arose in the High Court, because you were asked to review the High Court decisions, and you learnt then that the Post Office had within the organisation awareness of, as an example, the mismatch bug in 2010. That's one of the things you learned, okay? You then went on to prosecute matters in the Court of Appeal.
I responded to matters in the Court of Appeal.
You then went on to respond to matters in the Court of Appeal on behalf of the Post Office. Do you agree?
Yes.
Okay. So by the time it got to the Court of Appeal stage, you must have said to yourself, well, the Post Office appears to have known certain information, mismatch bug, remote access, that they didn't tell you about when you conducted your review. Do you agree?
That follows.
Right, okay. Did you address your mind to the fact that therefore you were also someone that had been misled by the Post Office, that they had failed in disclosing material to you? Did you turn your mind to that?
I think it was implicit in the fact that everything I read in the Horizon Issues judgment suggested that there were bugs, errors and defects which had never been brought to my attention.
Were you not a witness, Mr. Altman, to
No,
those?
no.
Can I finish the question?
Yeah, you finish.
Were you not therefore a witness based upon what you've just agreed?
No.
To those failures of disclosure to you, in other words, someone that could testify to the fact that here is the Post Office instructing senior Treasury Counsel, ex-senior Treasury Counsel, on serious matters requiring serious reviews, and yet they hadn't told you the truth.
I was never a witness. I was never likely to be a witness for the simple reason, Mr. Steen, that the Court of Appeal was looking at abuse of process at the time of the prosecutions and the convictions and not afterwards.
There was a decision made in relation to the response, as you put it, by the Post Office to those appeals, that a consideration was given to essentially looking at the evidence that related to the period up until 2013, the end of the prosecutions conducted by Poll.
That's not right. That's not right.
Okay, will you correct me then?
You're ignoring the disclosure management document, which is dated August 2020, in which it was made perfectly clear in paragraph 5 what the relevant period was. That was updated by the addendum disclosure management document of the 11th of January 2021, paragraphs 19 through to 21, which describe in absolute detail why the relevant period was picked. And as you know, Mr. Steen, because you were involved in the appeals, the Court of Appeal agreed.
The decision-making in relation to taking up to 2013 as being generally the period of time to consider for disclosure. Not entirely, but generally. That excluded all of the work that you did that followed 2013, the reviews you did of the High Court, what you did or didn't know potentially that was provided to the High Court, the other advice and work that you had done for the Post Office, didn't it?
Well, if you're saying that that was a deliberate decision, you're absolutely wrong.
I'm asking whether it excluded it, and then I'm going to ask you whether that was considered by you as being a defect in looking at the time period.
I think the answer to that question would fall to be answered by reference to decisions made post-February 2020. The significance of the date of February 2020 is that the
What I've
date.
got in this,
I understand.
it relates to the extent of the waiver of privilege, doesn't it?
I know, that's why I was asking questions about whether Mr. Altman considered rather than whether he discussed it with his team.
Anyway, I think on any view of it, you've had a very generous 15 minutes, Mr. Steen.
Thank you,
So
sir.
I think we're going to call it a day at that point.
Yes, sir.
Thank you, sir.
Thank you. Ms. Patrick, you have until 5 to 4, which gives you a very generous 15 minutes.
Thank you, sir. Mr Altman, my name's Angela Patrick. I act with Hudgell Solicitors and Mr Maloney KC for a number of sub-postmasters who were convicted and have since had their convictions quashed. I'd like to look at one issue, and you've referred to advices after the general review. I would look at the 2016 post-SWIFT review advice, and I really only want to look at, as one example, the review of Mrs Hamilton's case. You can see Mrs Hamilton sits next to me today. So if we could turn to Paul 3022854, please. And we can see there on page 1, it's headed Review of Post Office Limited Criminal Prosecutions. Just to start with, this was not a full independent review of all criminal prosecutions, was it?
Oh, no. These were cases selected for me by Post Office.
And I think I can help further. If we scroll to the bottom of the page at paragraph 3, you can see it yourself now, it's on screen. But just very briefly, the instruction was limited only to the question whether in a limited number of prosecutions you were asked to look at whether Paul had acted properly in charging both false accounting and theft.
Yes, this arose from the earlier SWIFT review.
Yeah, and if we can look very briefly, I'm conscious of time, at page 28, we see your conclusion on Mrs Hamilton's case file. And we can see there, while it cannot be said the material in this case, while it cannot be said on the material, I have seen in this case that the count of theft was charged and indicted solely and improperly to influence or encourage guilty pleas to the counts of false accounting. At this stage at which Mrs Hamilton had indicated she would plead guilty to the false accounting charges, the condition of repayment in return for the dropping of the count of theft, in my view, could lend itself to the possible, unfortunate allegation that what occurred provides evidence of the manipulation by the prosecution of the criminal process by securing the repayment of its losses through the criminal process, in particular by the charging of theft. Sorry, that took a little while to read out, but I thought for the transcript it's important to know where we're starting. If we could look now, sorry, I apologise. If we look now, there are some other explanations earlier in your advice for the basis of your approach. So if we could go to page 27, sorry, page 8, paragraph 27, please. And you'll see there about arguments to resist the allegation that it was improper to charge alternative offences, and you deal with the defendant was able to challenge the sufficiency of the evidence said to underlie the theft charge, and if so advised, to seek its dismissal. Indeed, it was open to the defendant to contest all charges and seek to make a submission of no case to answer, and so on. If so advised, the defendant could, through his advisers, seek disclosure, which might reasonably assist his case. And finally, it's the defendant's decision to plead guilty to a charge, and so on.
Sorry, forgive me, Ms. Patrick, is this in relation to Mrs. Hamilton or just
This is generally
the general,
approach.
yeah.
Yeah.
Yeah, thank you.
I just want to say there, you're emphasising there in paragraph 27 the role of the defence and the ability of the defence to seek disclosure. By this time in 2016, just to be absolutely clear, you had not been asked to look at how the Post Office typically responded to defence requests for disclosure of material relevant to bugs, errors or defects in Horizon.
Generally, no.
Thank you. And did your advice proceed on an assumption that the Post Office had complied with all of its obligations on disclosure in the face of any defence request?
Sorry, can you ask me that again?
Sorry, I think I may be trying to go too quickly. I apologise. Did your advice proceed on the assumption that the Post Office had complied with its obligations on disclosure in the face of defence requests? Essentially, were you assuming that the Post Office had done its job properly when it was asked for disclosure by the defence?
At the time of prosecution, you mean?
Indeed. And at the time in 2016, when you were being asked to look again at some of these cases?
Well, I think I must have been, yeah.
And can you recall whether, at that point in 2016, your confidence in being able to take that kind of assumption may have been impacted by what you knew by 2016, including the issues which had led to your original instruction?
Forgive me, ask me that again, please, Ms. Patrick.
Was your confidence in any assumption about what Paul might have done in respect of its disclosure duties impacted by what you knew in 2016, including the issues that led to your original instruction?
This review was not about bugs, errors and defects. This review, as you know, was for a particular purpose. That it was actually led on from what Mr. Beale was asking me about before, second sites.
Indeed, and I think we clarified that at the start.
Yeah, well, the point is that the disclosure decisions in the individual cases I was asked to look at did not cover bugs, errors and defects, but other issues. And therefore I wasn't looking at that. And did it impact on my confidence? I think in terms of what I saw here, and given that I was looking at a particular issue, no.
Thank you. You raised a particular concern about a condition placed on not proceeding with the theft charge. And if we look at page, 27, we can see at 107, you elaborate on that. I apologise, I'm trying to do this as quickly as possible. And again, you say the effect of the arrangement was that the prosecution was in effect allowing Mrs. Hamilton to buy her way out of a charge in which the House lawyer and counsel advised there was sufficiency of evidence. Second, the question might be asked if the prosecution felt the evidence was sufficient. Third, if Mrs. Hamilton did have a tenable defence to the count of theft, although I've seen no defence statement providing any defence, and I doubt that a defence statement was ever served, then it might be argued that the suggestion she should repay losses in return for the dropping of the theft count, which was the idea originating with the prosecution, blah, 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 blah. You say, again there, you're emphasising the lack of a tenable defence. We'll come back to that point. But do you recall, did the Post Office take any action on this advice you gave on the conditionality of its approach to the theft charge?
On this review in Mrs. Hamilton's case? Is that what you're asking me?
Yes.
I don't know.
Thank you. If we look very briefly, because I am conscious of time, at the specific consideration of Mrs. Hamilton's case and the facts therein, if we can scroll up a little to 25, at paras 100 to 101, and at 100, we won't repeat it. It sets out Mrs. Hamilton's conviction and the sentence that she was serving and the relevant undertaking to pay back the money is said to be owed to the post office. It goes on to say a little about the review, and you say, I agree, absent any tenable explanation from Mrs Hamilton consistent with her not being guilty of theft, there was indirect evidence to support the charge of theft, and you say why. And you say at the bottom there, in her prepared statement, which is the only word she uttered about the audit shortage, she appeared to blame a lack of training and shambolic post office systems. However, further investigation of her calls to the Horizon Help Desk, if we can scroll over to the next page, and to the NBSC helpline, failed to explain the loss of over £36,000 and, more importantly, the reason why she would need to falsify the declarations to such an extent, and so on. Now, absent any tenable explanation, this seems critical to your conclusions there. And we've seen the reference to the calls. In para 67...
Well, first of all, when I talk about indirect evidence, I think what I was talking about there was circumstantial evidence.
Indeed. I simply want to explore what you had seen at this stage. And we don't need to turn it up. We can if you want to. But at paragraph 67, it reads, insofar as calls to the helpline go...
Sorry, forgive me, which paragraph we looking
67.
at? That's not up on the screen.
I apologise. 67, please. It's page 18. It says, insofar as calls to the helpline go, the investigator had examined, and you set out what the investigator had examined in respect of the call logs. A number of calls had been reported, but the investigator concluded he could not see, and it quotes, anything that relates to a single or multiple discrepancy which would account for the audit deficit of £36,644.89. And you're saying that the investigator had examined, and I assume you would have seen the investigator's report by Mr. Brander.
I'm sure I must have done because I refer to it in this document.
Yeah. And I think here, looking at what you were actually looking at, you were looking in this advice at what the investigator had seen and what had then passed to the legal team for them to consider the charge. Is that fair?
I think so.
And that was the basis on which you were looking at whether any explanation had been offered by Mrs. Hamilton, tenable or otherwise. Is that fair?
I was looking at all of the evidence, and all of the evidence. When I say all of the evidence, I don't know if I simply had investigators' reports, advices, and that sort of thing. Possibly some of the background information I frankly can't remember after all of this time, but I was looking at all of the evidence.
Now, we won't go through it. We don't have time to go into the detail. We are all familiar with the conclusion of the Court of Appeal Criminal Division in Hamilton. Yeah. Mrs. Hamilton's been a case study in this inquiry. The inquiry's held reference to call logs and to statements, including by Andy Dunks of Fujitsu, and to treatment of ARQ, including in a statement by Penelope Thomas, again of Fujitsu. You wouldn't have reviewed the detail of the call logs yourself in 2016?
No, just I was presented with presumably summaries or other such documents which help me write what I wrote.
And you wouldn't have looked at the Fujitsu evidence in the case yourself or any ARQ material?
No.
A full independent investigation of what actually happened in Mrs. Hamilton's case was beyond your instructions on this advice. That's really just not what you were being asked to do by the Post Office at this time, was it?
No, I wasn't. I was being asked to look at one issue which had been raised by Jonathan Swift in the Swift Review.
Would it have been open to you to ask the Post Office to extend your instructions or to advise them that they might want to look more widely at the conduct of investigations?
Well, anything was open, but I was asked to do a specific task which had come out of the chairman's report, which was written by Jonathan Swift and Christopher Nyes. So, yes, technically open, but I don't think that it would have occurred to me to have suggested it.
I just want to look at one point in Mr. Brander's report. Could we look at Paul 3044389, please, and page 2. And before it comes up, I'll explain what I want to look at. We're looking at the description of the audit that was conducted at Mrs. Hamilton's branch very briefly, and I want to look at the bottom of page 2. We see that Mr. Stewart completed a full audit of the cash and stock and identified a deficit of 36,583.12, which is broken down as follows. We don't need to look at the breakdown. At the final paragraph on that page, Mr. Stewart also identified an additional 61.77 pence, shortage on horizon, which couldn't be accounted for, and thus the figure posted to late accounts was, and the figure is then given. In the context of your engagement with the Post Office and the issues that had been raised by Horizon, having read this report, would that information, that an additional sum during the audit, when Mrs. Hamilton wasn't present, had been found that simply couldn't be accounted for, did that give you any pause for concern?
I'm afraid, Ms. Patrick, the reality is when I looked through this, I suspect that didn't register in the way that after all of these years one can look at and confidently say, you know, there's a problem screaming out for examination. As I repeat, I was looking at all of these cases, and not just Mrs. Hamilton's, but I think 7 others, for a particular purpose, and identifying flaws, although looking back after all of these years, clearly significant, was not something that I would have registered.
But just to take pause, given what you knew by the time you were being instructed to provide this advice in 2016, you'd seen the second site report on bugs, you'd seen the Simon Clark advice, the Helen Rose report and its treatment, you'd conducted your own critical analysis of how historic prosecution policies at the Post Office had operated, and in this case, you'd raised your own concern about the approach to conditionality on theft in Mrs. Hamilton's case. Was there no basis at this time to be at least professionally curious as to whether all reasonable lines of inquiry, any tenable exploration, had properly been investigated by the Post Office?
Well, I come back to Ms. Patrick, what I said. You're talking about a figure of 61.77. You're assuming that I read it, I absorbed it, and I diverted my attention, or should have diverted my attention from what I was being asked to do. I'm afraid I didn't.
And one final point. You mentioned that your advice, you termed your general review, and Mr. Beers dealt with you with that. It was provided to the CCRC eventually. Do you know if this later advice in 2016, which included your view on the conditionality attached to the position on theft, do you know if that was provided to the CCRC?
I'm fairly confident it wasn't.
Thank you, Mr. Altman. That's all the questions I have.
Perfect timing, Ms. Patrick. Mr. Henry, 4:15 is your cut-off point.
Thank you, sir. Looking back, thinking about the iterative process, the negotiations, the horse trading, arm wrestling, whatever you call it, as to how you had your terms of reference established, and the carefully beveled or chamfered ambit of those terms of reference, do you think that you might have been set up?
By the Post Office?
Yes.
I mean, that's a very interesting proposition, Mr. Henry. I haven't quite thought about things like that. I have thought, I'll be frank with you, whether the fact I just left TC's room, Treasury Counsel's room, and I just finished my tenure as first senior Treasury Counsel, and looking at an email which I'd never seen before this week, about the different Queen's Counsel at the time people were looking at, whether they took comfort from the position I had been in. I've never thought that I was set up, I have to be frank with you, but it's a thought to wrestle with.
But this, I think, probably, unless I'm making an assumption, after many, many years assiduously acting on behalf of the Crown, how much of this sort of investigations, sort of white-collar work, effectively, had you done?
Around that time, actually, just around that, I think, I mean, I haven't gone back through my diary, Mr. Henry, you'll understand. But I was doing some, but in terms of white collar, I think I would have done some advisory work around that time. But if you're asking me, had I been prosecuting fraud cases, no.
No. Now, you said this morning, when Mr. Beer was asking you some questions, that you ought to have assessed for disclosure Gareth Jenkins' credibility. His credibility should have been considered for disclosure and disclosed with the benefit of hindsight. And Mr. Beer was asking you specifically through the lens of the Seema Misra case. And you said at that stage in your evidence, Misra was a slightly different case. The focus at that time was Horizon Online. Her branch was affected between 2005 and 2008, so it was a legacy Horizon issue. When it came to the appeals years later, the landscape was completely different. And then these words, one of the problems was that perhaps taking a naive view, the two new bugs in Horizon Online revealed to Second Sight, I felt could not be material in her case.
Yeah.
I mean, forgive me, but naivety is not an attribute normally associated with former First Senior Treasury Counsel.
And I was meaning it in terms of my understanding of the technicality.
I see.
So, in other words, Mr. Henry, of course, looking back, you're right, and the taint should have been disclosed, certainly to Mrs. Misra, and I've conceded that now probably for the 7th time. But what I mean by naivety is my naivety about the impact of a system like Horizon, whereby if you have two new bugs and Mrs. Misra's branch was legacy Horizon, I did not understand, and nobody put me right, that those bugs could not be referred backwards to the legacy system. That's what I meant by it. And
did you form the same view in respect of the receipts and payments mismatch bug when you became aware of that? That only affected, for example, I think you thought only Horizon Online.
Do you mean, forgive me, I've got a terrible throat. Do you mean the receipts and payments mismatch bug which Second Sight revealed in their interim report? I thought that was just Horizon Online.
I see.
Not least because, if my memory is right, Second Sight say it didn't arise until September 2010.
Well, leave that to one side. You've accepted that you're not perfect, that you're human and you're fallible. Do you accept that when you look back at this now, over a number of years, you made some mistakes in the advice you gave the Post Office?
I've conceded that.
Yes. And that those mistakes, if you had been aware of them at the time, they would have put you in conflict with your own client, wouldn't they?
I don't quite understand the question.
Well, I mean, let's just take two examples to sort of make it concrete. The 2010 cut-off date that you accepted was logical, proportionate, etc., etc. Do you accept now that that was a mistake?
No, I don't. As I said, because Mr. Beer asked me the same question, I don't.
I see. Well, I'll move on to something which you know I'm coming to because it's now the 8th time. The non-disclosure to Seema Misra of the Clark advice, you do accept that that was a mistake?
Of the advice itself?
Yes, not to disclose the fact that Gareth Jenkins was a tainted witness to Mrs. Misra's
Well, yeah, and forgive me,
lawyers.
there are two different things. The Clark advice is a document, if that's what you mean, no.
Yeah.
The information within it, yes.
Yes, exactly. Right.
Let me understand this. The Clark advice, as an advice, presumably would be legally privileged, and you wouldn't disclose that as a document, but you should have disclosed the relevant parts of it.
Well, the part which I've been asked about 8 times now, yes.
Yeah, well, and I'm in danger of making it 9, but it's just so that I've got it right.
Yeah.
It's not the document itself.
No.
It's part of the information contained in the document.
Yes.
Yeah. Now, what I'm trying to concentrate on here is that, and I hope that you will forgive me, I have to put a characterization on it, but the advice you were giving to the post office, for example, in connection with the CCRC, was engage with them by all means, appear to be helpful, but let them make the running.
I think the relationship with the CCRC is a different one, where the CCRC issues notices. But as I understood it, Post Office were cooperating and were engaging with the CCRC.
I see. Can I just put to you fairly and squarely, what I'm suggesting to you is that, regrettably, as is demonstrated by the monstrous delay before these matters went to appeal, the policy of disclosure was a lack of proactive engagement and candour with the CCRC. What do you say to that?
By Post Office?
Yes.
I know in later years Post Office were keen to carry on talking to the CCRC, but I think there came a point, in fact I know there came a point, when they would have been very happy if CCRC had stopped their interest.
Now, can I just ask you to consider this? You've accepted that you made mistakes, but what I'm going to be suggesting to you is that you were in the position, Mr. Altman, of being somebody who had been constantly backing the wrong horse so far as the strategic and tactical advice you've been giving the Post Office. Do you think that's unfair?
Strategic advice I had been given?
Yes, you've been giving them.
Giving?
Giving them, yeah, backing the wrong horse.
Post Office were my client.
Well, let's go to your note on the Horizon Issues judgment, which is POL 406396. And if we could go, please, to paragraph 4. And this is after the monumental judgment of Mr. Justice Fraser, and you had been first of all given sections A to L and then section M, and then you read the technical index. But the monumental judgment of Mr. Justice Fraser on the Horizon Issues judgment. And this is what you say at paragraph 4. In my view, these passages are a good reminder to any convicted claimant, as well as the CCRC, that this judgment has its limitations. The judge did not make any findings about individual convicted cases. He did refer to the Misra case at various points in the judgment, but in none does he analyse the evidence against her or make any particular finding which could advance any appeal in her case. Looking back on that now, Mr. Altman, that's a somewhat curious judgment by you, isn't it?
I was asked by Post Office, and I think it was Herbert Smith at that time, to point out to Post Office and them Post Office's exposure to risk, which is what Post Office always wanted to know. And this was my view of what the Horizon judgment or the limitations, as I understood it at that time, were.
The judge actually quotes Gareth Jenkins' evidence in Mrs. Misra's case, doesn't he?
I don't remember.
Well, he does.
I'm sure you're right. I'm not going to dispute it, Mr. Henry. I just don't remember.
Not to worry. Let's move on to paragraph 13. And you accept that what is Pol's duty if material comes to light after the conclusion of proceedings which might cast doubt on the safety of a conviction, then there's a duty to consider disclosure. This is just another way of saying that if there was any material non-disclosure at trial, Pol has a duty to consider the matter for disclosure. That said, I'm far from sure, in the light of the limitations in the Horizon judgment, that anyone can say presently that any material has come to light which might cast doubt on the safety of any of the convictions without there being a wholesale review of each and every one of them. Do you still stand by that judgment?
At the time, and in fact during the appeals, our argument was, and my view had always been, and I say our, it wasn't just me, it was the whole team, but I obviously take responsibility for it, was that the Court of Appeal would have to review each and every case specifically, yes.
I see. But anyway, there we have it. You've correctly stated the none test there, because obviously that is the none test, isn't it? If material comes to light after the conclusion of proceedings which might cast doubt on the safety of a conviction, then there's a duty to consider disclosure. You correct?
Well, it's part of the none test.
Yes, it is, isn't it? Let's go to a manuscript note which is attributed to Mr. Williams. It's POL 001 55554. And could we just make it a little bit bigger? Do you see that you are recorded to have said that you were perplexed about Mr. Justice Fraser? Can you remember saying something about being perplexed about him?
Well, it doesn't attribute that remark to me, but let's assume it was my remark.
I'm sorry to interrupt, but I thought that Mr. Beer said when this document was put to Mr. Altman that we didn't know who the author was.
This was a different document, Sir Wynne.
Different, I'm sorry.
Yeah. It certainly says at the top, conference with BAQC. As I say, it doesn't attribute that remark to me. Maybe I was perplexed, but what the perplexing was, I can't tell you.
It goes on to say whether it gives the CCRC what they want is questionable.
Yeah.
And then it goes down further. If we could just scroll up, please. Little assistance to CCRC beyond our understanding about Horizon.
And above that, if I may, no, and this is attributable to me, no findings, individual complainants affected by a bug or remote access on a branch account, mere potential, neither here nor there. So the way I read the judgment, and of course this advice or this view didn't age very well, because we all know that CCRC took a very global approach to the issues, as did the Court of Appeal, and I'm certainly not criticising, I understand precisely why. But at that time and later, certainly my view was, based on my understanding of this kind of situation, that the Court of Appeal would have to look at each individual case.
Yes.
Case specifically.
But you accept that you backed the wrong horse?
Well, I don't like that term, Mr. Henry, because the suggestion to me is I should have given different advice, or given advice which I felt was otherwise, and I didn't. This is the advice I gave. So if that's what you mean by a horse, you may think it's the wrong horse. At the time, I felt it was the right horse.
All right. Well, let's just go to POL 00337 and this is a note of a conference, or forgive me, consultation with you on the 20th of December 2019. And
I think I may have seen this in the further bundle I got this week.
Yes.
I don't think I'd seen it before then. Do you know whose note it is?
I'm afraid not, but it is on the system attributed to a consultation with you on the 20th of December.
And is it dated?
Forgive me?
Is this note dated?
I'm not sure if the note itself is dated, but you are definitely referenced in it, Mr. Altman.
Okay.
Could we scroll up, please? And we can see Horizon Issues judgment has its limitations, etc., etc. next paragraph, failed to see how anyone can make arguments on the basis of his convictions. Should that be conclusions?
I didn't write the notes, but
Of course.
I assume that ought to be the word, Mr. Henry. Yeah.
Next paragraph, CCRC under-resourced and overworked. CCRC has to do the work with PO cooperation, cannot make reference to the Court of Appeal unless they come to the view there is a reasonable prospect of success, etc., etc.
I doubt I'd have said reasonable because I think the test is real.
Yes. Go to the next page, please. And we've got, have we not, at the bottom of that page, under your view, BAQC view, last sentence, CCRC may never make a reference. Is that advice that you think you might have said on the 20th of December 2019?
Well, do you mind if we look at the paragraph under my initials to see what the advice was, which was to engage with them to show that we, in other words, Post Office, are being responsible. And this is, I mean, you say it's a note of the conference for the reasons you give, and the we may be the author of this document who was within Post Office, but be that as it may, we're being responsible, and that we, with, as it reads, to cooperate, and that we are willing to cooperate, but seek their guidance, want to avoid any missteps, might at the same time get an idea where they are, where they're not, would avoid the risk of Post Office being criticised for being self-serving, forgive me, or uncooperative.
Of course.
If didn't engage, and we'd done X when they wanted us to do Y, back to the drawing board, an auditable, sensible attitude to take shows Post Office in good light. Anything that we do as the stamp of approval can't go own way, would in my view be plain daft. CCRC may never make a reference. I mean, some of that could have been my advice. Some of it might have been the author of this note's takeout from my advice. And Mr. Henry, it's perfectly possible that I could have said, in the end, they may never make a reference.
Now, Mr. Altman, I have got very, very little time, and I've got two more topics to put to you with the Chairman's permission. So, if you will forgive me, if we don't put it up on the screen unless you specifically wish to, but you were shown a document during the lunch hour,
Yeah.
and I will give the reference in case you would like to see it put up on the screen. It's 003333839, and you're reported to have said in a note that the only basis upon which you would advise disclosing the draft Deloitte report.
Which draft? What's the date of this conference, please?
Should we go to the date of the conference then, please?
I think it was November 2016.
November 2016, thank you. The only basis on which you would advise disclosing the draft Deloitte report outside the constraints of Section 17, notice, is if it would help the Post Office. Now, obviously, that was advice that is attributed to you. Do you think that you might have said that?
I'm not sure of the context, but I did read very quickly the notes which you asked me to look at over the lunch hour, and I think in the end, after a round-table discussion when Roderick Williams turned up, I think the advice was that the Deloitte report, whatever it was, should go to the CCRC with a request for a notice for it.
Was it not that, in fact, they should make a Section 17 request, which would be covered, of course, by Section 25?
Yeah, inevitably at that time, yeah.
Well, I'm going to move on. Very last subject, one you're familiar with. You were asked why there wasn't an investigation into how Mr. Jenkins came to give misleading evidence that Mr. Clark said was fatally undermining of his credibility. And you responded, I was giving advice to the Post Office. I thought the advice I was giving was on the impact of that failure on the prosecutions and the convictions, and not the reason why he had failed to do it. Can you see the connection between the failure to investigate that issue and the validity or defensibility of the 2010 cut-off?
Ask me that again, please, Mr. Henry.
Well, ought there not to have been an investigation, Mr. Altman, into the extent of the bugs that Mr. Jenkins might have been aware of? Because that would be, of course, highly material to whether the 2010 cut-off was a defendable position.
With hindsight, the answer is an obvious yes. With the position I was in at the time and the realization that Gareth Jenkins had revealed himself those bugs to Second Sight, I suppose I had come to the view that if he had revealed those bugs to Second Sight, he would have revealed others that he knew.
So that was an assumption.
It was obviously a wrong assumption, but yes, it was an assumption, I suspect.
Thank you very much, Mr. Henry. You had your 2 extra points and made them. So I think that brings this evidence session to an end, does it not, Mr. Beer?
Yes, it does. Excuse me. Yes, it does, sir.
Right. Thank you, Mr. Altman, for your witness statement and for answering a great many detailed questions during the course of today. I'm grateful to you. So we'll continue tomorrow with the evidence of Mr. Clark.
That's right, sir. 9:45.
Right. Thank you very much.
Thank you, sir.